All right, it's 7 p.m. We'll call to order the May 2nd meeting of the Goochland County Planning Commission. Mrs. Parker, do we have a quorum?
Yes, sir, Mr. Chairman. We have a quorum.
All right, let's stand for the Pledge of Allegiance and the invocation.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please bow our heads. Dear Heavenly Father, please guide this commission to make the right decisions during our meeting tonight. Please watch over our families, friends, our men and women in uniform that help make our freedom possible. In your name we pray. Amen.
Amen.
And Mrs. Parker.
I'd like to introduce our new District 4 Planning Commission member, Mr. Kurt Patek.
Welcome.
Thank you. Glad to be here.
He's the Vice Chair of the Economic Development Authority and will be serving on both the EDA and the Planning Commission.
Busy man. All right, has everyone had an opportunity to look at the minutes from last month's meeting? Any comments, questions, concerns? Do we have a motion?
Yes, I move we approve the minutes as submitted. I second it.
It's been motioned and seconded. Any other discussion? All those in favor?
Aye.
Aye. All right. The next item we have is the citizens' comment period. This is for anything not on the agenda this evening. Please come forward, state your name and address. And seeing we have no citizen comment period, we will close the citizen comment period. Mrs. Parker, do we have any requests?
No requests for deferrals, additions, deletions, or changes to the order of the hearing.
Thank you very much. And let's start off with our public hearing items.
Our first item tonight is in District 2, CU 2019-00006, application filed by Cellco Partnership, DBA Verizon Wireless, requesting a conditional use permit to construct and maintain a 199-foot telecommunication tower on Whitehall Road, approximately a half-mile west of Cedar Plains Road, on tax map number 210260. The property is zoned A1 Agricultural General and is 56.36 acres. The conditional use permit is required by Article 2, Section 3.3 of the Goochland County Zoning Ordinance. The comprehensive plan designates this area as rural enhancement area.
Good evening, Greg Garrison, Principal Planner. This is a request for a conditional use permit for 199-foot telecommunication towers. The site is located south of Whitehall Road, just about a half mile west of Cedar Plains Road. 2035 comprehensive plan recommends rural enhancement for this area as well as the surrounding areas. Current zoning is agriculture general, and the parcels around it are zoned that way as well. The site is mostly wooded. It's all wooded, actually. There is an old logging road, it appears, that goes to the site in a zigzag fashion. You can kind of see it in the aerial there. A community meeting was held on February 27th, 2019. Staff, board member Mr. Alvarez, and 6 citizens attended that meeting. There were questions regarding the access easement and the construction traffic. A balloon test was conducted on February 28th, 2019, and the balloon was not visible from any public right-of-way. Access to the tower will be by an existing 60-foot wide easement. The applicant plans to improve 20 feet of the 60-foot easement with a 12-foot gravel road and a 4-foot clear zone on each side. The fire marshal has approved that design. The tower will be approximately 3,000 square feet south of Whitehall Road. Currently, there is a significant amount of large trees between the road and the tower. The tower is sited to fall completely within the property. This is the site plan zoomed out a little bit so you can actually see the existing easement, how they're proposing to access the tower. And this is just zoomed in a little bit. Should the Plan Commission recommend approval of this CUP, the following conditions are recommended. Number 1, a communication tower may be constructed and operated on the property subject to these conditions. Number 2 deals with the site plan as shown on Exhibit A. And number 3 is a POD shall be approved prior to the construction of the tower. Number 4 deals with the height, no more than 199 feet. Number 5 deals with the regulatory agencies, the FCC and the FAA. Number 6, the tower shall be secured with a fence. Number 7 deals with the, it shall not interfere with any television, radio, satellite transmissions, or public safety communication. Number 8 deals with the neutral color, non-reflective. Number 9 deals with the buffer, and that will be reviewed at the time of POD. Number 10 is a long condition. It deals with the co-location. There's been some back and forth on this condition. This is what the applicant and the county has agreed to. I won't read it all to you. It continues. Number 11, construction shall commence or be completed within 2 years. And number 12, internal access road, which has been vetted by the fire marshal, 12 feet wide with 4 feet of clearance on each side. Number 13 deals with expiration or removal after 90 days if the tower ceases operation. And number 14, your standard transfer or lease of the property. The conditional use permit, the Department of Community Development will be notified of that change. And that concludes my presentation. I'm happy to answer any questions that you may have.
Do you have any questions for Mr. Garrison?
I assume all these restrictions are similar to all the other towers? we've done?
Yes, sir, they are.
Thank you very much. Would the applicant like to state anything?
Good evening, Mr. Chairman, members of the commission. My name is Lori Schweller, attorney with Williams Mullen, and we represent Verizon Wireless. Also with me is Stuart Squire, who is zoning manager with GD Insights, consultant to Verizon Wireless. I have a quick presentation for you. Just want to show you a few things. The site is almost identical to the one that you saw last month on Hawktown Road, so I won't take too long to point out a few additional facts. The site is on property owned by Roger Gathright, a little over 56 acres, and as you can see, that property is landlocked, and that property has the benefit of an easement, which was put to record in 1982 over property of 4L Corporation. This slide is showing you our survey, and Verizon Wireless has, as part of its lease, a 20-foot access and utility easement over Mr.Gathright's existing 60-foot wide easement. So Verizon only has a 20-foot easement. Just wanted to make that clear, and I'm showing you that there. And then it continues on to the subject property, to the compound, which is 100 by 100 feet. The lease area, the compound itself within that is 80 by 80, just like the one on Hawktown Road. The elevation is the same as well. We're proposing a monopole, 195 feet with 4-foot lightning rod, which means no lighting is required, and there would be capacity for at least 3 additional future providers. As Mr. Garrison explained, the balloon test revealed no visibility from the surrounding area, and so the balloon test photographs are not showing you the balloon in any of the photographs. So you can see the views that we took here, but because it is set so far back on the property and the property is heavily wooded, it should not be visible based on the results of our balloon test. Also, as previously explained, we have worked out the details of the conditions we discussed last month. specifically those including regarding the access road. The fire marshal determined that a 12-foot road with 4-foot clearance on either side with certain standards as set out in the condition would be sufficient for safety purposes. So that condition was finalized, as well as the one for county co-location. So that set of conditions, Verizon Wireless is acceptable to them, and we hope that those can be on our Hawktown Road application as well. I'll be happy to take any questions.
Any questions?
I have one. You said it's space for 4 locations, Verizon. Now, there's 3 left?
Oh, space.
Space.
It will be engineered to hold at least 3 additional to
The
Verizon.
county would take one of those, so it'll ask 2 more?
That's right. So if someone wanted to co-locate on that monopole, then Verizon would be required to, you have a right of first refusal. So the Verizon would be required to notify the county to let you know someone's interested in co-locating there. Are you interested in going on that spot? Right.
I know that in the last case we discussed propagation map. Is there any idea of distance that this would cover without providing a propagation map?
Typically, without having viewed one, for a monopole of this size, 199 feet, depending on obstructions and so on, you can get 3 miles, 2.5 to 3 miles is typically what we say. Sometimes it's more than that. It depends on
Topography
circumstances.
Okay.
Yes.
All right. Any other questions? Thank you.
Thank you.
We will now open the public hearing for this application. Anyone wishing to come speak in favor or against this application, please come forward, state your name and address.
Mr. Chairman, my name is Darvin Satterwhite. I represent 4L Corporation. I've got a handout, if I could just give it to you before we get started. It may simplify what I have to present to you, if it pleases the chair.
That'd be fine. Thank you.
Thank you.
Chairman, what I have there before you really summarizes what our position is. I know the applicant understands we take issue with whether or not they have a legal easement. I'm not arguing that tonight. That's a legal question. Maybe that can be resolved elsewhere. But let's assume, for the sake of argument, that it is a valid easement. I'm not admitting that, but let's assume it. What you have there, the tab A is what our legal argument is against the validity of the easement. But tab B, if you look at that, it gives the width of the utility easement. It's not a lot of legalese in there. It's pretty clear language. The utility easement's 10 feet wide. It's not 20 feet. And if you look at the next tab, tab C, you'll see that the site plans, as have been presented to you here tonight, call for an access and utility easement of 20 feet. And you can't get 20 feet width of whatever your product is in easement within a 10-foot area. I mean, I can do the math on that. It doesn't work. If you look also, there is no construction easement whatsoever granted in that easement document that you see there under tab B. So whoever's going to go in there and put in utility easements, and I understand it'd be electrical and phone, at least that's what we were informed. You got to do it within a 10-foot area, not a 20-foot area. You don't have a construction easement on either side to work from, so you got to do your work within the 10-foot utility easement. But you have a site plan before you tonight that shows something very different. And it's not just, we don't look at these things and say, oh, that's a private matter. Let 4L work that out with Verizon. Your last tab there shows your own guidelines in granting a conditional use permit. 3 of them are actually applicable, but the last one that I've listed there actually applies to easements themselves: access easements, drainage easements, utility easements. You don't have a 20-foot utility easement over my client's property, Verizon doesn't, to make this project work. Now, if they have a site plan before you that works, maybe we have something else to look at, but that's not what you have before you tonight. So we are opposed to the application. We believe it's contrary to the easement document. And the road plans also show a road going in there. If you look at those road plans, I believe they have a culvert listed, which is going to show channeling of water. There's no drainage easements over my client's property. So I think the application fails in many respects. It just doesn't work with regard to the easements that make supposedly the cell tower viable. So for those reasons, we would ask for your consideration of opposition to this application, and that recommendation move on to the Board of Supervisors. I'd be happy to answer any questions that you may have. My clients are here tonight as well if they have anything that they could address with regard to construction issues. They are in the construction business.
Right. Thank you.
Okay.
Anyone else?
I think the attorney needs to know. I think you need to address this.
Good evening, members of the commission. If the chair has a question or maybe wants to give the applicant a rebuttal.
Yeah, that would be fine in regard to the easement. First of all, let's close the public hearing, and then we can give the applicant an opportunity to answer. Thank you.
Thank you, Mr. Chairman. The easement that Verizon has by virtue of its lease with Roger Gathright is over an existing 60-foot easement. That 60-foot easement is for access, and it also discusses a 10-foot utility easement within the access easement. Verizon's easement is a 20-foot access and utility easement. It doesn't mean we'll use the whole 20 feet for utilities. That's just the way it's characterized. The differences that we have with Mr. Satterwhite's argument are not based on those factual details, but are based on the legal premise that under Virginia law, Virginia case law, if you have an easement, and granted, keep in mind that these run with the land, so it didn't matter that it was granted by the owner of the 4L Corporation property before 4L Corporation owned it. That doesn't matter. They are the servient landholder, and the Gathright parcel is the dominant land. And so regardless of who owns it, that easement exists, and Verizon has it through Roger Gathright. Just want to make that point. But that easement can be used for any purpose if it's not restricted in the deed of easement. This is well-settled Virginia law under many cases. There are limits there. You can't expand the use. Mr. Gathright couldn't build a subdivision and have 100 cars a day go over that easement. That might be an expansion that overburdens the servient parcel. But just having an access road that's already permitted, in fact, it's supposed to be a 60-foot wide gravel access road. It isn't, and we don't want that, but that's what's already there. So what we're proposing is simply to use the access road that's already there, use the easement that's already there, and within that, just lay the fiber in the road as is already permitted, and that it will not be an expansion of the existing easement.
Anyone else have any questions? Thank you.
Thank you.
I have a question for the county in regard to distance to neighborhoods. The Bexley Wood Run subdivision, which is off of Riddles Bridge Road, what's the, I know this is not in the presentation, but I did receive some concern from several of the neighbors in that subdivision.
Can you, where's that at? Is that up
It's going to be to the south.
to the south?
I'm not sure if you have maps available.
Can you, I mean, what kind of opposition was it?
No, they were looking for better coverage, better cellular coverage. I didn't know the distance, and this was something that I was,
Yeah, I don't have that.
all right,
I'm sorry.
thank you.
I would like to remind everyone, the commission, that we're not approving a site plan tonight.
Correct.
We are approving or not approving, we're making a vote on whether or not the use is permitted. Site plan is reviewed with staff. It's when we get into drainage, it's when we get into stormwater requirements, things of that nature. So,
Yeah, we're looking
just-
whether or not it fits the use, and it is a CUP.
Yes, sir.
Condition on the site plan. Condition number 2 is on that site plan.
As an exhibit.
Correct.
What are your comments?
Anyone else have any?
I didn't hear what was said just then. What did Mr. Satterwhite say?
Mr. Satterwhite was saying, we have an exhibit, and we have exhibits on other plans as well. They're conceptual in nature.
Okay.
So we're not, this does not get into stormwater. This doesn't get into easements. It's a private matter.
Thank you. Anyone else? Anyone else? Do we have a motion?
You know, other than this little legal snag, in the past, we have pretty much approved these cell phone towers. And I just don't see that we have a valid reason for not recommending this one for approval. So I'm recommending for approval.
We have a motion from Mr. Myers,
I'll second.
and we have a second from Mr. Duke. All of those in favor?
Aye.
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 We're making the motion to, or the vote is approved to recommend approval for the conditional use permit for the tower. Thank you. Next item, Mrs. Franklin.
Our next item is in District 2, RZ 2019-00003, application filed by Kevin and Tammy Wolf, requesting zoning reclassification of 13.09 acres from A1 agricultural general to RR residential rural with proffer to create one additional lot on tax map number 29-5-0-1-E. The property is located at 2678 Dogtown Road. The comprehensive plan designates this area as rural enhancement area.
Thank you, Ms. Parker. Mr. Chairman, members of the commission, Tom Coleman, Principal Planner. As Ms. Parker stated, this is a rezoning request to rezone approximately 13 acres from an agricultural zoning to a rural residential zoning to create a two-lot subdivision. This property is centrally located in the county. The subject property and all the surrounding properties are zoned agriculturally. The subject property and all the surrounding properties are designated rural enhancement area in the comprehensive plan. Looking at the aerial photo, you can see there are a number of rural residential uses in close proximity to the site. Just with this slide, just highlighting the existing house, and it's circled in yellow where that's located. They've indicated they're going to divide the property into two approximately 6.5 acre parcels, and the dotted line just gives you an approximation of about half, splitting that property in half. With the subdivision ordinance, Anytime we have a parent track and all the by right splits have been taken from that parent track, the property must be rezoned from an agricultural district to a residential district to file the subdivision application. The applicant did provide a proffer that this property will not be divided any further. The county's cash proffer policy does not apply to rezoning cases that just create one additional lot. Therefore, there's no, the county's capital impacts model is not invoked with this application. There was a community meeting held in March. Planning Commissioner Duke attended to that. None of the neighbors attended that meeting, so there was no one there really to express any opposition to this. The applicant did submit one proffer that says that the 13.9 acres would be divided into two separate parcels, approximately 6.5 acres, one each. That concludes my presentation. I'd be happy to answer any questions.
I'm just going to have a question. A few months ago, we had another case where the applicant wanted to subdivide a piece of property, and I think the county was afraid that once they did it, he would be free to for future subdivision without actually coming before the board. How does this case differ from that one? I think it was some doctor. I'm not gonna call his name. I don't even remember his name, but
I think with this application, based on the minimum 5-acre parcel, they do not have enough acreage to create additional subdivisions.
Okay.
Maybe with that other case, the residual property, they could have gotten further lots out, more lots out of it.
okay. They just wanted to be consistent.
My question would have to do with ingress, egress to the lot or the parcel, the new created parcel, the road that services the existing lot. Is there an issue with that?
No, they will have to provide access to the existing lot, is served by private road, and
How many homes are currently on that road?
I apologize.
How many homes are currently served by that road?
There are two, looking at the aerial photo, I'm going to direct your attention to the screen back here. This is the road right here that's coming up. So we would count this lot number one. Since this house is frontage on Dogtown, we wouldn't count that one. But this one and the second home would have access, so that would be the third home that would have access to it. So it would have to be a private road, standard road to serve that
So
lot.
we're not going over 5 lots being served by that road?
No public road would be required.
That was my concern. Thank you. Any others? All right. Would the applicant like to come forward? Please state your name and address.
Excuse me. My name is Kevin Wolf. I live in Powhatan County. Excuse me. 2467 West Deer Path Drive in Powhatan. And Mr. Chairman and other board members, I do appreciate your consideration for this application. My wife and I actually purchased this piece of property back in March and determined that we could divide this into 2 separate lots after talking with the staff here at Goochland County due to the limitations of the 5 acres based on your question. We did apply to have that divided. Our plans are is to actually, we're in the process of trying to fix the house up that's currently there, doing some painting and that kind of stuff, get it back up to where it needs to be to have a decent renters within the property. The driveway that actually accesses that is a deeded right-of-way back to that particular road that goes back to that house. So basically, we would be requesting that deeded right-of-way be granted to go through our piece of property to get back to a second piece of property that we would own. So we would basically be asking for that, extension of that right-of-way through our first piece back to the second piece. And that would give us access to be able to build at a later date another home, maybe a year or 2 down the road, to have another rental property there. And that's basically what the status is of our request. And I certainly do appreciate it. Any questions that you have, I'd be more than happy to answer.
Any questions for the applicant? No, sir. Thank you.
Thank you.
We will now open the public hearing. Anyone wish to speak in support or opposition, please come forward, state your name and address. Seeing none, we'll close the public hearing. Gentlemen, do we have any further discussion? Do we have a motion?
I so move we approve this application.
I second it.
We have a motion and a second. All those in favor?
Aye.
Motion for recommend approval for this subdivision to the board. Number 9, old business. Do
No.
we have any?
No business, Mr. Chairman?
And any other business?
No, sir.
And let's adjourn. Thank you.